shackled, arrested, no warning, no phone call, no lawyer, thrown into a van, restrained, relocated, then flown across the world to a place you've never seen, where no one knows your name and the language feels foreign in your mouth. Now imagine it's you, or your son, or your daughter, and no one, no agency, no court, no country believes you belong here. That's not a story from the past. That's not a cautionary tale. That's 2025. We like to believe citizenship comes with a promise, a border the government cannot cross, a line that, once you're on the right side of it, offers protection, rights, and dignity. But over the last few months, that line has blurred. And in some cases, it's vanished altogether. Under a set of newly revived and expanded immigration powers, the federal government has begun detaining and deporting individuals, some with legal status, some awaiting hearings, and yes, even some who are fully documented U.S. citizens. The machinery is moving fast, too fast for due process, too fast for verification, too fast to distinguish between a policy decision and a personal tragedy. What began as targeted enforcement has evolved into a system capable of removing people without a trial, without legal defense, and in some cases, without even confirming identity. And the worst part? This isn't an accident. It's a calculated shift in how immigration is handled, one that leans on old laws, emergency rulings, and administrative shortcuts to bypass the usual checks and balances. Title 42 may be gone, but what replaced it is broader, bolder, and far more dangerous. Think about it. If the state can detain someone born here, raise questions about their legitimacy, and remove them from the country they call home, then we have to ask ourselves a much harder question. What does being American actually protect you from? To understand how the federal government is now removing people, and that's including U.S. citizens, you have to start with the laws quietly powering the machine. Some of them are new, some are old, but all of them, when combined, form a legal framework that makes this level of fast-track deportation not only possible, but difficult to stop. The first major tool in play is expanded expedited removal, a policy change reinstated and extended in early 2025. Originally introduced during Trump's first term, this rule allows immigration officers to remove individuals from the U.S. without a hearing before an immigration judge if they cannot prove they've been in the country continuously for at least 2 years. It bypasses traditional due process and significantly reduces the window for legal intervention. What changed this time around is how far that authority now reaches. Previously limited to those caught near the border, the 2025 revision removed geographic restrictions, giving ICE the power to detain and deport anyone anywhere in the U.S. on the spot, based only on perceived status and limited documentation. But that's not the only statute being used. The administration also invoked the Alien Enemies Act, a law originally passed in 1798, yes, the 18th century, which gives the president broad authority to detain or remove citizens of foreign nations deemed hostile or dangerous in times of conflict. While this law was designed for wartime threats, the current application stretches its meaning. In practice, it's being used to justify deportations to third-party countries that agree to accept foreign nationals, even when those individuals are neither citizens of those countries nor formally charged with any crime. Legal scholars have raised alarms over this interpretation, but so far, court challenges have struggled to gain traction. Layered on top of that is Title 8, the broader immigration enforcement statute that governs everything from detention to processing to removal. Title 8 has always allowed for a range of immigration enforcement actions, but under the current administration, it's being executed with heightened speed and little transparency. While Title 42 was formally ended in 2023, Title 8 stepped in as the default mechanism, and it's far more expansive. Then there's the role of the Supreme Court's shadow docket, which is a term used to describe emergency rulings issued without full hearings or published opinions. Throughout the early months of 2025, Multiple lower courts attempted to place limits on expanded removals and third country deportations, especially in cases involving vulnerable individuals or those with pending asylum claims. But in response, the Supreme Court issued a series of emergency stays which keeps the policies in place while challenges play out, effectively giving the administration a green light to continue enforcement without interruption. All of this creates a layered legal shield. Expedited removal allows for swift action. The Alien Enemies Act provides cover for unusual deportation destinations. Title 8 ensures broad authority over immigration matters, and the Supreme Court's emergency rulings keep it all operational while avoiding lengthy legal review. On paper, it's a tightly stitched web of authority. In practice, it leaves room for error, and those errors are not theoretical, they're lived. Policies rarely announce their true intentions. They're passed in the language of security, framed around order, and sold as solutions. What makes this moment so dangerous isn't just the laws, it's how those laws quietly reshaped behavior, how they made something exceptional feel routine, how a series of executive decisions, legal tools, and Supreme Court approvals transformed deportation from a process into a reflex. At first glance, the 2025 policy shift looked like more of the same. Expedited removals had already been used before. Border enforcement had always existed in some form, and the idea of prioritizing national security wasn't new. But something changed in tone and execution. This wasn't just about addressing a surge at the southern border. This became about speed, about numbers, about visible strength, and most of all, about control. The expanded expedited removal order didn't just increase the number of people being processed, it altered how enforcement agencies approach their work. In cities far from the border, places like Chicago, Baltimore, and Atlanta, ICE officers began conducting quiet sweeps, sometimes in plain clothes, sometimes without warrants. Individuals were picked up during traffic stops, courthouse visits, or even while walking home from work. In some cases, they were released within hours after proving their citizenship. In others, they were transferred out of state and held for days without being told why. What started as a border policy became a nationwide dragnet. For years, immigration enforcement had operated with some form of restraint. Officers were trained to ask questions, verify status, and follow protocol. But the 2025 changes created a cultural shift inside the agencies themselves. Officers were encouraged to act decisively, to lean into discretion, and to worry less about litigation. Internal memos and policy briefs emphasized efficiency. Detention quotas quietly rose. Deportation metrics became a new form of success. At the same time, public communication went quiet. There were no primetime addresses, no televised announcements. The only people who really noticed were the ones it affected, and even they weren't always sure what had happened. In interviews conducted with families impacted by the new policies, a common thread emerged: confusion. Many weren't told where their loved ones were taken. Some were told nothing at all. Others, when they called ICE or DHS hotlines, were met with silence, reroutes, or outright dismissal. One mother searching for her teenage son was told to check back next week. She didn't know if he had been deported, detained, or worse. This is what happens when legal power outpaces public oversight. And this is how it spreads, quietly, under the radar, built into systems that already run on complexity and silence. There are no press conferences for mistaken identities, no news tickers when a veteran is wrongly detained, and by the time courts can respond, the damage is already done. That's what makes this moment so critical, because the shift we're witnessing isn't just about immigration policy, it's about the normalization of a system that can disappear people first and verify later. And it's happening without a national debate, because abstract laws are one thing, but when the wrong people start getting caught, the consequences stop being political. They become personal. Let's clear something up before anyone says, well, they must have done something wrong, or I thought the government had to give you a hearing first. Because yeah, on paper, that's what the Constitution says. But what's happening in practice tells a very different story. The Supreme Court has ruled, more than once, that due process applies before the government can detain or deport someone. And I'm not just talking about citizens. I'm talking about lawful immigrants, green card holders, even people accused of being threats to national security. The law is clear. You don't get to disappear someone just because you want them gone. Back in 2001, the court decided a case called Zadvidas versus Davis. A man was being held indefinitely after a deportation order, but no country would take him. The government wanted to keep him locked up with no timeline. The court said absolutely not. If you're going to hold someone, you better have a valid reason, and you better be able to prove that removal is likely. Otherwise, you're violating the core of due process. Liberty isn't optional. Then in 1982, there was Landon versus Plasencia. A woman, lawful permanent resident, was returning to the U.S. after visiting family in Mexico. Border agents tried to block her re-entry without a hearing. The court shut that down. They said once someone's part of this country, even as a resident, you can't just shut the door on them without review. Due process doesn't disappear at the airport. Even in 2004, in the middle of the war on terror, the court ruled in Hamdi versus Rumsfeld that a U.S. citizen labeled an enemy combatant still had a right to a fair process, not a perfect process, but a real one. A citizen detained without charge still had the right to challenge that detention in front of someone neutral. So if those people, accused terrorists, longtime residents, stateless migrants, get due process, then how do we justify stripping it away from someone standing on American soil who just happens to speak Spanish or have a tribal ID in their wallet? Here's how: expedited removal. Under a section of the Immigration Code, INA 235B1, officers are now allowed to detain and deport people without a judge, without a lawyer, and without any real chance to defend themselves. If you can't prove you've been in the U.S. continuously for 2 years, they can put you on a plane within 48 hours. No hearing, no appeal, just gone. And let's be honest, who carries 2 years of documentation in their back pocket? Who's prepared to prove their whole life story during a traffic stop? This isn't a small policy quirk. It's a direct contradiction of everything the Supreme Court has said about due process for decades. But now, under these new rules, officers are making decisions that used to belong to courts. And when mistakes happen, when citizens get caught in that system, there's no safety net to catch them. So no, don't say, I thought the law protected people. It does until it doesn't. Until we let speed outrun justice. Until we let fear write policy. Until we let process be treated like an inconvenience. And that's exactly what's happening right now. By the numbers as of mid-2025, ICE had already made more than 100,000 arrests. That's over 1,200 people a day across cities and small towns, not just at the southern border. And while the administration maintains those arrests target illegal entries and non-citizens, a growing number of U.S. citizens have found themselves trapped in the same system, held without charges, and in some cases, deported entirely. Take Julio Noriega, a Chicago native. He was picked up while walking to a job interview on January 31st. No record, no warrant. Officers claimed they had reason to believe he was in the country unlawfully. He spent 10 hours shackled in a van, then locked inside a holding facility where he was denied food, water, or access to his phone. Julio repeatedly told them he was a U.S. citizen. It didn't matter. He only got released after ICE agents ran his social security number and confirmed what he had said from the beginning. They didn't apologize. They didn't offer him a ride. They dropped him off, alone, in the middle of the night, miles from where he was taken. In Virginia, Jency Machado was pulled over while driving to work on March 5th. Officers drew weapons and ordered him out of the car. He was handcuffed, placed in the back of a vehicle, and told he was being taken to a processing center for undocumented immigrants. It was only after he presented a federally issued real ID license right there in the car that they let him go. The entire incident lasted less than an hour, but for Jency, that hour became a lifetime of distrust. The only explanation he was given, he fit a profile. That profile has become a quiet weapon, especially against Native Americans and Puerto Ricans. In January alone, over a dozen indigenous people were detained near their homes in the Navajo Nation. They were asked for green cards, tribal IDs dismissed as insufficient. Some were held for nearly 9 hours while ICE tried to verify their status through federal databases not designed to recognize tribal documentation. In the eyes of the system, centuries of land treaties and native sovereignty meant nothing. Puerto Ricans faced the same treatment. In Newark, a veteran was detained in a workplace raid, his documents ignored until a supervisor stepped in. In Milwaukee, an entire family was held after speaking Spanish at a grocery store. They were American citizens, born on U.S. soil, but their passports weren't on them, and that was enough to justify their detention. No charges were filed, but the incident left their young daughter shaken. She now carries a copy of her birth certificate in her backpack. And these aren't isolated incidents. A child with cancer was separated from her mother and held in ICE custody for nearly 2 weeks in Oregon before a federal judge intervened. A woman named Andrea Velez was taken from her apartment by masked agents and vanished into the system. Her family didn't know where she was for 3 days. Another man, Jose Hermosillo, was detained in Arizona despite showing his citizenship documents. ICE insisted he was lying. He spent 10 days in custody until the state attorney general got involved. In April, a disabled Army veteran named George Reedes was pepper sprayed during a raid in Sacramento. A citizen, a man who served this country. 3 days he spent in holding before being released. No charges, no explanation. His case made headlines only because he filed a lawsuit. Most stories like his never do. Then came the third country deportations. Over 130 Venezuelans, some of whom were reportedly U.S. residents or dual nationals, were rounded up under the Alien Enemies Act, flown out, and left in El Salvador's notorious prison system. One of them, known in court documents only as JGG, had lived in the U.S. for over a decade. His removal was challenged by multiple advocacy groups. A lower court ruled the deportation unconstitutional, but by then, he was already gone. This is what happens when speed outruns process, when discretion overrides citizenship, when a system starts acting as if legal status is just a suggestion, flexible, revocable, and often ignored. ICE claims these are mistakes, but when the same mistakes keep happening in the same types of communities with the same types of people, they stop looking accidental. They start looking designed. And if the government is willing to detain a disabled veteran, a sick child, a tribal elder, or a citizen on his way to work, what makes the rest of us so sure we're safe? Because once a nation gives itself permission to ignore your papers, your birthplace, and your rights, then being American becomes a gamble, not a guarantee. The stories may span cities, age groups, and identities, but the pattern is hard to ignore. The people being swept up, detained, and in some cases deported, they all tend to fall along familiar lines. They're not random. They're not drawn from every slice of American life. They're overwhelmingly people of color, often bilingual, often living in working-class neighborhoods, and almost always disconnected from legal resources. You start to see it in the numbers. While ICE doesn't publish breakdowns by race or mistaken identity, multiple watchdog groups have flagged a disproportionate impact on Latino communities, Native American citizens, and immigrants from Africa and the Caribbean. Between January and June of 2025, an estimated 12,000 ICE arrests occurred in counties with a majority Hispanic population, representing nearly 1 in 8 of all arrests, despite those counties representing a much smaller share of the national population. The detentions don't always happen during raids. Many come during traffic stops, courthouse appearances, or hospital visits. Individuals are questioned about their status, sometimes without legal cause, and once flagged, they enter a system that's faster than it is accurate. In multiple cases, officers failed to verify citizenship through standard systems like SAVE, which stands for Systematic Alien Verification for Entitlements, or failed to check state DMV records that would have immediately shown lawful status. When legal representation is absent, which it often is for expedited removals, the margin for error expands. And under the 2025 policies, immigration officers have sole discretion to initiate removal proceedings. They don't need to present evidence in court. They don't need a judge's approval. They simply need to believe that an individual is deportable, and the burden of proof shifts onto the person being detained, even if that person is a citizen. It's worth noting how documentation plays a role. A large number of those detained carried tribal IDs, consular birth certificates, or older driver's licenses that, while legally valid, don't match the newer federal Real ID standards. These variations in identification are enough to trigger detainment under the new framework. And for people with non-English names or accents, even a correct ID doesn't always guarantee release. Then there's geography. A growing number of arrests are happening far from the border in places like Baltimore, Nashville, Charlotte, and Cleveland, where local ICE field offices have ramped up activity. In these areas, the individuals targeted often have deep community ties, some born and raised in their neighborhoods, others longtime residents with US-born children. Overlay that with data from immigration courts, and the pattern becomes sharper. In 2024, prior to the Trump administration's return, the percentage of asylum seekers granted hearings was already declining, sitting at around 42% nationally. By mid-2025, after the new enforcement guidelines took effect, that number dropped closer to 27%, with many asylum claims rejected outright under Title VIII fast-track protocols, some before evidence was even submitted. Even within federal agencies, concern is growing. A leaked memo from DHS's Office for Civil Rights and Civil Liberties flagged repeat procedural failures in verifying citizenship before initiating removal. The memo cited at least 57 internal complaints filed by DHS staff regarding wrongful detainment protocols between February and May 2025. The agency has not publicly commented on the contents. None of this is happening in a vacuum. It's happening in neighborhoods where English isn't always the first language spoken at home, in regions where federal agents assume immigration status based on skin tone, surname, or dialect. It's happening in schools, workplaces, and places of worship. It's happening where people live, quietly, with roots that run deep, and that's the larger pattern. These aren't just enforcement errors, they're the outcome of a system designed to move fast, operate quietly, and rarely look back. A system that sees difference as suspicion, and where "show me your papers" becomes more than just a historical phrase, it becomes policy. We're not talking about isolated cases. We're talking about a landscape of enforcement that targets identity as much as status, where proof of citizenship can be questioned, and the burden of truth falls not on the state, but on the person in handcuffs. The question isn't whether these patterns exist. It's whether we're willing to admit what they reveal about how we define belonging and who we're willing to protect when the system gets it wrong. By the summer of 2025, the scope of the deportation effort had become too big to downplay, even for those trying. In just 6 months, ICE reported over 100,000 arrests, marking a 46% increase from the same period in 2023. The agency expanded operations far beyond the southern border, with arrest clusters emerging in cities like Philadelphia, Houston, Phoenix, and even Salt Lake City. Enforcement wasn't just up, it was spreading. Out of those 100,000 arrests, immigration lawyers and rights groups estimate that at least 300 to 500 individuals may have been legal U.S. citizens, residents, or otherwise unlawfully detained. While only 4 deportations of U.S. citizens have been formally confirmed, the real number could be higher. Many cases don't become public unless litigation is filed or the individual manages to return and speak out. Some never do. The Alien Enemies Act, a law originally passed in 1798 during the John Adams presidency, was responsible for one of the most controversial moves yet. More than 130 Venezuelan migrants, some of whom were legal U.S. residents, were deported to El Salvador's notorious Tecoluca prison facility under the guise of national security. Among them was JGG, a man who had lived in Florida for over a decade. Despite having no criminal record and a pending legal appeal, he was forcibly removed. A federal judge later ruled the deportation unlawful, but the ruling came after he was already in a prison cell thousands of miles away. Meanwhile, the Department of Homeland Security's own Office for Civil Rights flagged dozens of internal complaints, specifically 57 between February and May 2025, relating to mistaken identity, failure to verify status, and improper detentions of citizens. These weren't outsider allegations. These came from within the federal system. Legal infrastructure, too, has buckled. The immigration court backlog passed 2.7 million pending cases nationwide, a historic high. With fewer hearings granted under expedited removal, many individuals, including asylum seekers and green card holders, were processed and deported in under 48 hours. Advocates argue that such timelines make it nearly impossible to gather necessary documents, contact a lawyer, or even notify family. The cost of these detentions isn't just human, it's financial. DHS spends approximately $158 per detainee per day, and with thousands being held daily, the budget for detention-related expenses crossed $1.3 billion by mid-year. That's before factoring in litigation costs, lawsuit settlements, and transportation expenses related to third-country removals. Despite court challenges, very few rulings have stopped or even slowed enforcement. That's largely due to the Supreme Court's continued use of the shadow docket, which we touched on earlier in this article. But it's a process in which emergency rulings are issued without public hearings or detailed written opinions. Between January and July 2025, the court issued 6 emergency stays, allowing continued enforcement of third-country deportations and expanded expedited removals. In each case, lower courts had blocked or limited enforcement on constitutional grounds. But in every instance, the High Court granted the administration's request to override those rulings while appeals played out. Civil liberties groups responded with legal pressure. The ACLU, National Immigration Law Center, and Southern Poverty Law Center have filed a joint lawsuit on behalf of 14 U.S. citizens who were detained by ICE between February and April 2025. The suit accuses DHS and ICE of violating the 5th and 14th Amendments, specifically the right to due process, equal protection under the law, and protection from unlawful seizure. And the numbers keep climbing. As of July 1st, at least 19 states had reported wrongful detentions of confirmed U.S. citizens. Nearly 1 in 5 complaints submitted to immigration attorneys involved claims of legal status being ignored. And among those cases, over 70% involved individuals who were either Latino, Black, Indigenous, or visibly foreign-born, even if they were not. Behind the numbers is a financial engine most Americans never see. As of mid-2025, ICE is offering signing bonuses of up to $45,000 to new or returning agents, with additional reports citing $1,500 in incentives per deportation completed. Active duty field agents are now earning as much as $6,000 to $7,500 per week, depending on assignment, with premium pay offered for high-volume zones and rapid response teams. The agency's enforcement budget has ballooned from $4 billion to over $45 billion, driven by a mandate to hire 10,000 new agents and meet escalating removal targets. These aren't just operational increases, they're performance-based payouts. But beneath the policy is something more human. Everyone has bills. Everyone has stress. I've been behind on my mortgage. I've dodged calls from creditors. I've prayed for another month of grace. So what happens when someone just trying to keep their head above water is handed an opportunity that pays $1,500 per person they remove? What happens when the man standing on the other side of that badge starts seeing people as paychecks? Not intentionally, but out of pressure, out of debt, out of need. What happens when "I think he might be undocumented" is enough to justify a check? We've already seen the mistakes. Veterans, children, citizens. So how do we justify a financial reward system in a process where we've proven we can't always get it right? Enforcement can't be profit-driven, because when money becomes the motivator, mistakes aren't just inevitable, they're incentivized. And in that equation, humanity is the first thing to go. Taking all the information together points to a system operating at high speed but low accuracy, a system that prioritizes removal over review. And when the outcome is final, when someone is put on a plane, dropped into a country they've never known, stripped of everything, they have no pathway back unless someone powerful enough decides to undo it. This isn't just a policy question anymore, it's a constitutional one. What we're witnessing is a test of law, of accountability, and of whether identity itself can be erased by error or by design. This isn't about undocumented immigrants in the shadows. This is about people who were born here, who served, who paid taxes, who speak English, Spanish, Navajo, Creole, who went to high school in Michigan or worked night shifts in Houston. These are citizens, legal residents, green card holders, parents, children, veterans, people who belong here and still got caught. What ties many of them together isn't a legal status, it's appearance, accent, surname, where they live, the side of town they're on. What they don't have is access to attorneys, political connections, or the kind of money and privilege that could stop ICE at the door. That's the quiet bias behind it all. Legal identity only matters if someone believes it, and belief is too often built on optics, not evidence. What's happening is structural. This is the collision of multiple powers, expedited removals, third country deportations, federal discretion, and emergency judicial approval, creating a system where people can be removed from their lives in hours, not days, not weeks, hours. ICE has redefined its role. The Supreme Court has temporarily looked away, and DHS has institutionalized error by allowing field agents to override evidence, skip hearings, and act on assumption. If someone doesn't respond the right way or doesn't have the right paperwork in their pocket, the state now has permission to treat them as deportable. The legal term for this is presumptive removability. The real-world term is guilty until proven innocent. The pivot happened in January 2025 when Executive Order 14,159 revived and expanded expedited removal powers and activated the Alien Enemies Act to support third country deportations. It accelerated again in February when the first Supreme Court emergency stay allowed removals to continue despite a lower court ruling. From there, the system locked in. But the cultural shift began even earlier. Enforcement agencies were already leaning into speed and broad discretion. What changed this year was the removal of restraint. ICE officers were told to act, not to ask. Courtrooms were bypassed. Paper trails got thinner, and for people caught in the system, the timeline between arrest and removal began shrinking to 48 hours or less. Understand, it's not isolated to the border. It's in Baltimore, Charlotte, Phoenix, Cleveland, Fresno, and parts of rural Mississippi and Indiana. These aren't border towns. They're working-class communities where multilingual families live and where the system often assumes foreign means unauthorized. ICE has executed removals in at least 19 states with confirmed wrongful detentions in over a dozen, including California, Texas, Illinois, New York, Florida, Arizona, and Oregon. Community advocates in places like Albuquerque and Louisville have reported cases of citizens being detained and later released with no explanation and sometimes no record of the arrest at all. This is national, and that's what makes it dangerous. If you don't understand why it matters and why you should care, it's because if the government can detain and deport someone who belongs here, someone who can prove it, then what is citizenship really worth? We've built an immigration system that says it respects borders, law, and status. But the actions of 2025 tell a different story. They tell us that being right on paper doesn't guarantee protection in practice, that the system can miss you, mislabel you, and remove you, and when it does, there's no emergency brake. Let's be clear about something else too. I'm not arguing for illegal immigration. I don't support people skipping the line. I think there should be a process, I think about it like traffic. We've all seen the off ramp backed up for miles, and someone flies down the shoulder trying to cut in at the last second. It's not fair. It's not right. Everybody's trying to get somewhere. That's how I see immigration. Go through the process. Stand in line like the rest of us. But if we believe in that process, then we should also believe in protecting it. And that means making sure the people we detain and the people we deport are actually the people who don't belong. Because if the system gets it wrong and someone's freedom is treated like a clerical error, that's not justice. That's a failure, and it's one we all pay for. And if that's true, then it's not just immigrants who need to worry. It's every American who looks or sounds like someone the government is comfortable ignoring. Understand that every day this continues, more people are swept up, more families are separated, more identities are questioned, and the burden of proof remains unevenly applied. So the question isn't just how this happened, the question is whether we're paying attention now that it has. Because what's happening isn't a glitch. It's not a system error. It's the system working exactly as someone intended, fast, unchecked, and willing to cross the line if no one pushes back. That's why this matters, because once a nation gets comfortable skipping the rules, it doesn't always stop with the people we expect. And when that line between citizen and suspect fades, we all have something to lose.